Good morning all. Today I am going to take subject matter of contract of sale. Goods means every kind of movable property other than actionable claims and money and includes stock and shares, growing crops, grass and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. Trademark, patent, copyright, goodwill, water, gas, electricity are all goods. The term goods excludes money. Money itself cannot be subject of a sale. The actionable claims are things which a person cannot make use of but which can be claimed by him by means of a legal action. Actionable claims and money are not goods. An actionable claim is something which is enforceable only by action in a court of law. Example, a debt due. The goods which forms the subject matter of contract of sale can be of the following types. Goods may be classified as existing goods, future goods, contingent goods. Existing goods may be of three types such as specific goods, ascertain goods and unascertain goods. Existing goods, goods which are owned or possessed by the seller at the time of contract. Example, A is the manufacturers of watches. He sell 100 watches to B. It is a sale of existing goods because watches are owned by A. Specific goods, goods identified and agreed upon at the time of contract of sale is made. Example, X owns a number of cows, promises to sell one of them to Y. The contract is for unspecified goods, but if the cow that is to be sold has been singled out, the contract is for specific goods. A certain goods identified by the parties subsequent to the information of the contract of sale. The identification takes place at a later date. Example, if a rice dealer agrees to supply one bag of rice from his godown to a buyer, it is a sale of uncertain goods because it is not known which bag will be delivered by. When a particular bag is noted and marked for delivery, it becomes ascertain goods. Uncertain goods indicate by description and not specifically identified. These are the goods which are not specifically identified and agreed at the time when the contract of sale is made. The seller in this case has an option, rather the right to supply any goods of the kind or the quality contract for. Future goods which are to be manufactured or acquired by the seller after the contract of sale is made. Example, A agrees to purchase entire crop of sugarcane of B farms at the rate of rupees 500 per quintal. This is an agreement to sell the future goods. Contingent goods the acquisition of which by the seller depends upon contingency which may or not be happen. They are also a type of future goods and therefore a contract for sale of contingent goods operates as an agreement to sell. Example, X agreed to sell Y 100 bags of rice provided he is able to purchase it from its present owner. This is an agreement for the sale of contingent goods. Sales and agreement to sell. When under a contract of sale, the property in the good is transferred from the seller to the buyer, it is called sale. Sale takes place when there is a transfer of ownership in goods from the seller to the buyer and it is an executed contract. Example, X sell his car to Y for rupees 3 lakhs. Agreement to sell means a contract of sale under which the transfer of property in goods is to take place at a future date of subject to some conditions thereafter to be fulfilled. Generally, sales means transfer to property from one person to another in consideration of the price paid or promise of another valuable consideration. But where under a contract of sale of the transfer of the property in the goods is to take place at the future time or subject to some conditions thereafter to be fulfilled. The contract is called an agreement to sell. Thus, in case of agreement to sell, the transfer of property is goods does not take place immediately but a future date. Example, X access to X agrees to purchase Y scooters for rupees 22,000, provides Y stands surety for him with Z. It is an agreement to sell for Y. It is become a sale when the condition is fulfilled by Y. Distinction between sale and an agreement to sell. Nature of contract. Sale is an executed contract, that is, it is a present contract, whereas agreement to sell is an executory contract, that is, which is yet to be executed and therefore is a future contract. Transfer of property. In case of sale, the transfer of property from the seller to the buyer takes place immediately, so that the seller is no more the owner of the goods sold. In case of agreement to sell, the transfer of property is to take place at a future date or subject to some conditions to be fulfilled. Seller continues to be the owner. Risk of loss. In a sale, as the buyer becomes the owner of the goods, he has to suffer the loss if the goods are subsequently damaged or destroyed. But in the case of agreement to sell, since ownership does not pass to the buyer, the risk also does not pass to him and remains with the seller. Type of goods. In a sale, the subject matter can be only the existing and specific type, whereas in an agreement to sell, the future and continuous goods are usually the subject matter. Sometimes it is uncertain existing goods. Consequence of breach by the buyer. In a sale, in case of breach by the buyer, the seller can sue for price of the goods even if the goods are in his own possession, or he can exercise the right of line stoppage in transit or resell the goods. But in an agreement to sell, if the buyer commits defaults, the seller may sue for damage only and not for the price, even though the goods are in the possession of the buyer. Right of resale. In a sale, the seller cannot resell the goods. In an agreement to sell, in case of resale, the buyer who takes the goods for consideration and without notice of the prior agreement get a good title. Nature of rights. A sale, the buyer being the owner of the goods acquires all proprietary rights in the goods as against the world at large, but in an agreement to sell gives a right to the buyer against a particular person only, and in case of breach of contract he can sue the seller for damages for breach and not for the recovery of goods. Insolvency of the buyer. In a sale, if the buyer becomes insolvent before giving the price, the official receiver or assignee can claim the goods because the ownership of the goods has passed to the buyer. The seller's right is to get a relatable dividend from the estate of the insolvent buyer. Insolvency of the seller. In a sale, if the seller becomes insolvent, the buyer is entitled to recover the goods from the assignee for official receiver because the ownership of goods has passed to the buyer. In an agreement to sell, if the buyer has already paid the price and sellers become insolvent by the buyer can claim only a relatable dividend and not the goods. Sale and other similar transaction. There are some other transactions which are very close to a contract of sale but are quite different from sale of goods. Therefore, it is necessary to examine the distinguishing features of such transactions. Thank you.